Why a valid judgment still may not allow overseas remittances. SAFE's Substantive Review and Practical Insights. Baokui Guan, foreign investment lawyer, recommended by 7 embassies in Beijing, January 7, 2026. A foreign client recently won a final civil judgment in China. Liability was cleared. The amount was fixed. And the Chinese subsidiary was ready to pay. They assumed the next step was simple: purchase FX and remit the funds overseas. The bank refused. Reason: even with a valid judgment, SAFE must review the underlying legal relationship. This payment cannot be remitted. This surprises many foreign investors. In China, a judgment does not automatically create eligibility for outward remittances. Banks and SAFE must still verify that the underlying transaction is genuine, compliant, and falls within a permitted FX category. 1. Legal logic. A judgment confirms civil liability, but it does not create a cross-border payment right. Replace FX compliance requirements, compelling SAFE or banks to approve remittances if the underlying transaction is not eligible for cross-border payments. A judgment cannot make it eligible. 2. Judicial position. Courts consistently hold that FX approval is administrative, not judicial. Enforcement ends once RMB is paid domestically. Refusal to remit, refusal to enforce. Thus, winning a case, automatic remittance. 3. What SAFE actually reviews. Banks examined whether the underlying transaction has a cross-border nature, whether the payment fits a permitted FX category, whether required registrations, loans, capital, employment were completed, whether the payer is qualified to make such payments. If the judgment only confirms a domestic debt, FX remittances will be denied. 4. When domestic collection becomes the only option. If SAFE finds non-compliance, the creditor can only receive RMB in a domestic account. No FX conversion. No outward remittances. This often creates tax and repatriation challenges for foreign parties. 5. Practical lessons from cross-border disputes and embassy-referred cases. Several points are clear. A judgment cannot cure FX non-compliance. Foreign employees must ensure proper employment registration. Foreign shareholders must register capital contributions and loans. Cross-border contracts must be drafted with FX rules in mind. Expectations must be managed early. Some payments simply cannot go out. Conclusion: China's FX system operates independently from judicial enforcement. For foreign investors and overseas creditors, legal victory: FX remittance. SAFE reviews the transaction, not the judgment. Compliance must be planned from the beginning, otherwise enforcement may end at the RMB stage.